On 26th October 2006, India witnessed a major breakthrough in women's rights movements in the country. This was the day when Protection of Women from Domestic Violence Act came into force. And why was this a major breakthrough? Because oftentimes violence that a woman faces inside the confines of her family and of her home is seen as a personal matter, a private problem, if you may. But this law came with the promise of protecting women against this sort of violence, and not just provide her with that protection, but also provide her with civil remedies, such as providing her with support through the proceedings, with maintenance, custody, right of residence. So this law was a major breakthrough in that sense, and this is the law that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani, you have Bhadra, Sinha, and we have with us Aparna Bhat, who's a lawyer practicing at the Supreme Court.
Yes, in fact, Aparna is the apt person to talk on the law, because she has handled many cases revolving around women's and child rights issue, and her contribution to the acid attack guidelines is immense. And apart from that, Aparna also played a very important role relating to the sexual online abuses, right, which many women are witnessing today. And I think her intervention also led to the creation of an online registry, one can say, where I think now you have a list of sexual offenders, right, Aparna?
The place where you can report online.
That's right.
Cybercrime.gov.in was created because of her.
Yes. So today we have her with us to talk on the Domestic Violence Act. Aparna, the first question is that why was the need felt to have the Domestic Violence Act, and what actually propelled the government to bring this law?
Thank you, Apoorva and Bhadra. One of the things which was, it was actually a result of a long-standing movement, if I can say. Because if you look at the laws relating to women, especially in realizing their economic rights, you can seek maintenance. Married women can seek maintenance, but it's a very difficult process, time consuming. And then you can also go to seek remedy against cruelty, on grounds of cruelty against your husband and in-laws. But then you look at the scenario where a woman is abused in the house. She has to leave home, and then she has to fight for her rights. Now, how is it possible for a woman who has no resources to leave her home and then fight? And what would actually happen was many of them would continue to stay in their own home and continue to suffer the violence, or they would go to their parental home, and most times they may not have been welcome in that place. So there were these issues. Besides that, it was felt that there was a need to have a remedy which is largely economical, focuses on economics, makes sure she gets some money quickly, and have a speedy remedy. That was the whole idea in bringing this act. I must say, I think the person who pioneered this drafting and everything was Advocate Indira Jaising. I've had the privilege of working with her, but not on this law. She brought this act, came much into force. I think it was a result of a long-standing demand and a women's movement which started it. And it was felt it was necessary to have something like this.
Mm-hmm. So when we talk about domestic violence, so what all really gets covered under domestic violence? And is this remedy available only to the married women in the household, or it can also be accessed by somebody who's an unmarried woman in the family?
That is the main thing. It is not only limited to married women. For example, if you have an unmarried woman who's being abused by her brother, she can also go and seek remedy under this act, because it's about, basically there has to be a domestic relationship. It defines what is a domestic relationship. Now, every relationship that is domestic, it can be matrimonial, it can be fraternal. It can also be a relationship where there are no these legally recognized relationships. For example, if you're in a live-in relationship with somebody, but you're living with the person, so you have an emotional relationship. There is no marriage, you are not a brother or sister, but you happen to be a girlfriend of the man, or you're just living with somebody, that's also covered under this law. So that was a huge, significant, I would say, a movement, a monumental change that brought in where for the first time, live-in partners could also seek rights under this act.
In fact, I think this would be the first law that actually acknowledged a relationship called the living-in relationship.
In fact, I had filed the first case on live-in relationship also, and we had got an interim order from the one of the Delhi courts recognizing that relationship. Yeah.
So what kind of remedies can a woman actually seek under this law?
Yeah. So she can seek maintenance, which as I was saying, economic remedy. She can seek residence. By residence, it can be residence that she can demand that a person gives her residence, or it can be a residence where she is currently living and ask the person living there to move out. Only thing that she cannot seek, it's very important because lots of times what happens, we get confused. She cannot seek a residence which is not a matrimonial home. You know, for example, if she was living in a home in Delhi, which may not belong to her husband, but she happens to be living her, that's a matrimonial home. And the family happens to have a property elsewhere where she has not lived post her marriage. So she cannot ask her rights over those properties. But if she's living in a particular house, when she gets married, she moves into a home, even though the property is not her husband's, she can still ask those rights. That's because, you know, maintenance law is so nuanced. I can tell you the way, and people also manipulate the law. I've had many cases where what they would actually do is they will be living in a joint family, but on paper, the husband will rent a house somewhere, an unlivable house somewhere, show that I moved out and this is my rent receipt, I've leased out. And then the in-laws will ask her to vacate, saying that your husband is not here anymore. This property is not yours. And the courts don't recognize that house as her house. And she's really in it. Where will she go? Now, this is the manipulation of the law. But something that the courts do not recognize, that law has been manipulated, because what happens is at the end of the day in the court, what will the court believe? The court will believe the evidence that you present. Right. And if the husband comes up with a lease deed saying that I'm leased this property, I'm paying rent, I'm paying electricity, I'm paying all these things, even though he's not living there, then the court will find that he has a different house. He has to move there. And she has no right to live here, because maintenance you can seek from your husband. You can't seek from your in-laws. Okay. Right? So these were some of the things that the Act addressed. Another important thing that the Act addressed was addressed the emotional cruelty. Okay. Because that was something which was there in the other law, but it was extremely vague. And for someone to actually demonstrate that she's been emotionally abused, it was very difficult, because there was no legal recognition. So it talks of economic abuse, emotional abuse, and the other violence, physical violence that she's anyway going through. So I would say economic abuse that it recognized and the emotional abuse that it recognized are two very significant contributions, in addition to, of course, fraternal and living relationship that this Act made.
So it sounds very revolutionary in that sense to have recognized at that time live-in relationships, emotional abuse and everything. So now it does provide for a lot of remedies for women as well, right? If you could elaborate a bit on that maybe.
Yeah, so one is maintenance, which I was saying, residence, injunction against a person coming to her residence, safety of children in the interim. And yeah, these are the things that a woman can get.
So when you talk about injunction, what does it really mean? Can she kind of seek an order from the court restraining her husband to enter the house?
Yes, she can. Okay.
She
can ask for restraining her husband to enter the house, disturb her possession, and also disturb the children's living conditions, whatever they are. These are all the orders that the court can pass.
Mm-hmm. And would this also extend to the in-laws? Can this be extended to the in-laws?
It can be. Now, so when you file a complaint, if the complaint is filed against about, let's say, 4 people, so she can seek relief against all of them, all 4 of them. Yes, she can do that. Mm-hmm. And also children, for example, if suppose you have brothers who are against whom you file, you can. So you choose your respondents. But the key thing is you have to establish that you have a domestic relationship. That's important. So you can't, if you do not have a domestic relationship with the person, you can't make that person a respondent in the case.
Mm-hmm. So then can a complaint under DV Act be filed against a woman also? A complaint by a woman against a woman, as in the Bhadra?
It can be filed. But it can be filed.
Okay, so this law allows that as well.
Yeah. Okay.
But since we're talking about that discussion, whenever there's a gender, a specific law, there's always a demand for making it gender neutral. And that demand, I think, has been coming up with regard to Domestic Violence Act as well. In fact, we did a story recently on how this man has tried to file a domestic violence case against his wife, and the court has even issued summons to her. So the debate sort of resurfaced. What do you have to say about that debate?
See, under this Act, a man cannot file this is not a gender neutral law. Mm-hmm. And secondly, I want to say this, because this is something lots of groups have been talking about, there are these men's groups who are proclaiming under the tagline of save the family, as if women break the family. And then, they're propagating that these laws are very draconian again for men and families, they should not be there. I want to say this. There are some women who abuse this law. There is absolutely no doubt about it. But there are people who abuse all laws, people who abuse tax laws, people who abuse criminal law, people who abuse all kinds of laws. So to single out women, to say that because we have a small fraction of women, 1 or 2 here and there, abusing the law, because of which we need to have gender neutral laws with respect to that, I think it is not warranted. We live in a patriarchal society where it's expected of a lot of us, even us, we are expected to perform some roles. And then when you challenge that roles, you are labeled as a person who's not in a position to keep her home together. We are all labeled like that, right? So given that, and given the number of cases that women are dealing with, if you look at statistically, there are enormous number of women and a large number of women who are actually deprived of the resources, deprived of livelihood to their children, and physically attacked and ostracized both by their own family as well as the in-laws. Given this kind of a dimension and the economic thing, that the setback that she faces, I think we are not ready to have a man demanding domestic violence at this stage. That time may come when we are, totally at par, but it has not come so far, and I don't think it is ready. It's one visit to the court where these cases are being heard now, you will see the reality. The number of women who come and number of women who bring their children there because they really don't have any other place to leave them.
Right.
And it's depressing to see that. And the volume of cases that we have, and where I've seen, when I go to lower court, sometimes I do see cases where the judge is actually negotiating with the husband. Oh no, it's okay, give her 1,000 rupees, give her 2,000 rupees. Can you imagine if the person has to go to court to get 1,000 or 2,000 rupees in this day, and the cost of living are so high. So you can imagine the dynamics of what's happening here. So I don't think it's warranted just now. Right. Some men may have suffered in their marriage. Some men may have been subjected to all kinds of atrocities at the hands of their wives. I don't deny that. Human mentality, some people are like that. It's a different thing. But those numbers do not, warrant an intervention of that kind.
Right.
I wanted to ask you one thing, Aparna. When a woman goes in for a DV Act, can she parallelly also seek redressal under different laws like 125 CRPC or the 498A IPC, where you deal with dowry harassment?
Yeah.
So there is no bar on a woman.
There is no bar. The 498 is a criminal case. It's completely a criminal case where the police get involved, they investigate the case, they charge sheet, and the trial will happen, and maybe a conviction will happen. That's a 498A. It's a completely different dimension. 125 CRPC is a secular law that's available for seeking maintenance. So the proceedings are similar to the Domestic Violence Act, except that Domestic Violence Act, you have a protection officer who's supposed to be there, who's supposed to engage with you, understand your problem. And if you cannot go to court, the protection officer can file a report which will help you take the case forward. These provisions are there in the Domestic Violence Act. But you can claim maintenance under these two as well as other acts like Hindu Adoptions Maintenance, Hindu Marriage Act, Hindu Adoptions and Maintenance Act. These are all cases, laws also where you can claim maintenance. Normally what happens is, suppose there are multiple cases that a woman has filed seeking maintenance. When the court orders maintenance, it will take into account the maintenance she's got in other cases. Okay. And if she's got substantial maintenance in some other case, then the court will say that since you're already getting maintenance there, you will not get maintenance here. That's what it does. But there is no bar in filing it.
So multiple proceedings can
be filed. Women do file because sometimes they feel this court is faster, and sometimes they also, depending on the kind of advice they get.
Okay.
Right? So on that basis, they can file multiple cases. But court always takes into account how much money she's being paid, what relief she's got. Those kind of things they take into account.
So, of course, the maintenance part, you mentioned that the courts take into account what sort of maintenance she's gotten in the other cases. But do the findings of other cases sort of impact each other?
It will, right? Because at the end of the day, each court, a finding is a judicial finding. A judge has found this has happened. It will influence, negative, positive, both influences will be there. Because if in a case proceedings under 125, suppose the judge has found that her case is devoid of any merits, for example, it will impact the other cases also. Yeah, it will definitely impact.
So you mentioned protection officers, and could you, for our viewers, maybe briefly elaborate on what happens when a woman approaches a court and files a case under the DV Act? When is such an officer appointed? What sort of assistance can she get in terms of, say, medical or legal assistance, or on those lines? If you could.
Under the Act, there is this cadre called protection officers. Okay, a woman can go to the protection officer first and file what they call a DIR, I think domestic incident report. Right. So basically, she will go and tell, this is what happened to me. The protection officer is supposed to reduce that into a paper, find a report, and also maybe do a field visit to understand the thing, and then forward that to the court. And then so that it's a facilitation process. Because believe me, court is very intimidating.
Right.
You know, and the not just the physical structure of the court, the whole process is intimidating even for people who have no problem. Suppose today you have to get an affidavit signed. Somebody says go to the court and get it attested. You do get very unnerved, right? You want to take somebody with you, because I think the court and the police station are two very unnerving places for people to go. So the idea was to take her to a place which is more friendly and easier for us to access, where the person sits with her and talks to her in a language that she understands. Right? I don't think a judge has a time to engage with a woman and explain to her what are they. Now here is a person who's available to you to give you those spaces. And then we have fairly robust legal services authority everywhere. Some are better than the other. Of course, there are these issues with any state-run programs. And legal aid is available to women, and legal aid for women is available across the country free of cost, no matter what her economic or social status is. Right. That's something women get legal aid, right? So these are some of the things that is available to her. Medical, again, is through a referral to a government hospital. I don't think there's any additional benefit she gets.
Okay.
It's a referral which she can anyway seek. So a protection officer can help her. There's also an option to go to the court directly. If she doesn't want to go to protection officer, she can even go to the court directly. Sometimes it's necessary to go to the court directly because you will need an injunction. Suppose you're facing, suppose your husband has threatened that I'm going to take the child away, and that can happen tomorrow. You don't have the time to go to protection officer and everything else. You want to go to the court immediately to get an immediate order. It's possible. So there is no bar in going.
Okay. For the benefit of our viewers, Aparna, if you could just briefly explain the difference between 498A IPC, which deals with dowry harassment, and the DV Act, because many a times people, get confused between the two laws.
So 498A is an Indian Penal Code. It's a section introduced again after a huge movement and demand by people saying that there were lots of dowry deaths were happening in, I think I'm talking about 80s when, there was a lot of things. The amendment came. It recognizes cruelty of women from the in-laws, and also dowry demand is another section, another aspect of this. Now, in 498A, you go to the police station. You file a criminal complaint against whoever against whom you have allegations of. 498A is a police case. The police will register the FIR if they find merit in your case. Post that, they'll investigate. When they investigate, they'll file a charge sheet. If they find merit, they'll file a charge sheet under Section 123 of Civil Criminal Procedure Code. It goes to a criminal court. A magistrate deals with this case. People will be called to give evidence. So the complainant, that's the wife, the woman who goes there, is only a prosecution witness in this case.
Right.
That's her right. So what can you get from 498A? You can send your in-laws and husband to jail. That's all you will get. And conviction. It doesn't give you any money. Yeah, so it's a criminal case. As against that, 125 CRPC, which is a maintenance case, and Domestic Violence Act, they give you civil remedies. You can go, and this is not a case where you can send them to jail. You basically compel them to give you residence, maintenance, and also look after children, or lots of other things. Yeah.
So to contest a DV Act case, do you need to kind of gather some sort of evidence, some sort of testimony? Is that required?
You see, Domestic Violence Act, when you file a case, suppose somebody goes to court and say that my husband has a lot of resources. Then you have to substantiate the resources, right? How do you know resources are there? Now, in the Delhi High Court, there are 2-3 case judgments which happened. I will try to give you the name before we end this. They found that people were willfully hiding information. So the Delhi High Court made a format which is mandatory. It's followed across the country now. And different courts have different ways of doing it, wherein both sides have to disclose on affidavit the income tax returns for the last 3 years that they have to file. They have to file a detail of all assets they own, all liabilities. So now, before you begin the case, after the summons are issued and file a reply, it's mandatory to file those evidence from both sides. So when you get these details, so you're in a better footing because information is there. On affidavit, you have to disclose what properties you own, what rental amount you're getting, and what is your income tax returns, because these are documents which you're declaring to the government, at least officially whatever is available that you're declared. And likewise, even the wife, sometimes she may be richer than the husband, not always, but sometimes maybe she's richer. So she has to also disclose that these assets I already have and I pay income tax or I don't pay income tax. And also you have to indicate what are your monthly expenditure. So this will help the court determine, because you can't sit in judgment over what is ideal income for anybody. What is good for me may not be good for somebody else. They may find that very low, and somebody else may find my living status very high, right? So instead of getting into that kind of judgment, the court asks you to tell you what is the lifestyle, what is the kind of expenditure you have, and that will help them determine the case. So, and as to answer your question, it is important to know what kind of resources your husband has before you file the case, because if you do not know that information and you go to the court without preparation, and if the husband tries to hide the assets, then you'll get nothing. And there are people, please remember, in business communities, let's say it's a family business.
Right.
The family owns the business. It is not in your husband's name, but he's getting benefit out of it. The benefit may be given to him in kind of by way of cash.
Right.
So there may be no income that is transferred to you, right? But so you will have these people living in fancy homes and having a very fancy lifestyles, having fancy cars, but nothing is in your husband's name. But if he's using it, you're entitled to get part of it, because the maintenance laws across board recognizes that when you seek maintenance, the maintenance should be commensurate to the lifestyle that you are leading, you're used to. So given that kind of a law that we have, it's important to be able to realize that, right? You should be able to have information. So it is information. It's important that you should have all economic information about your husband available to you. Yeah.
So the law seems to have covered most aspects to sort of provide as much protection and assistance to women as possible. But how is the actual implementation in your experience? For example, since you mentioned protection officers, are there enough on the ground? How is it when the cases go to the court? Is there a long wait period for women to get compensation? In your experience, how is the implementation?
You see, Delhi is one of the states where implementation is better than the rest of many other places. I'm not going to say better than the other places. But one of the few places where protection officer as a cadre was appointed.
Okay.
In many places, and I'm not talking about current experience, things may have changed now. Many years back, I had gone to Uttar Pradesh, where I had seen that the protection officer had multiple other responsibilities.
Okay.
He was probation officer under Probation of Offenders Act. He was I know there was some officer which was demanded. He has to be a child marriage prohibition officer. He was that also. So many other roles were given to one person. So if you give so many roles to one person, how can the person perform all those roles, right? So obviously, the performance quality gets compromised. That is one aspect which I think many states will have a problem with. That is one thing. And even in Delhi, where I practice and where I go to these courts, sometimes what I see is the volume of cases is so high that today the act says within 4 months you should dispose. It is impossible to dispose within 4 months, and you can't blame the judges. The judges are hearing something like 70 to 80 cases sometimes, 60, 70, 80 cases every day. And in the span of 8 hours that they sit in the court, and they have other cases also. It's not only domestic violence cases, they have other cases also. How is it physically possible for them to hear all these cases and give justice? Because you have to spend at least 15 minutes per case to understand what is the woman saying, what is her problem, what kind of relief she can get. So because of it, there are a lot of delays. The infrastructure and the number of courts that we have for domestic violence cases are very low.
Okay.
Do we have special courts to handle or hear domestic violence cases?
So they have these Mahila courts, okay? And then Mahila courts are not hearing only this. Mahila courts are hearing 498A cases. Mahila courts are also hearing this. Mahila courts, I think, depends on the case, they're hearing many other cases. So let's assume that they're hearing only 498A and domestic violence case and maybe 125. Even then, it's a lot of work for them, right? So and the volume, and there's one judge for the entire district of Delhi. For example, I'm talking about Delhi.
Oh, just one judge for the entire...
One judge, or maybe 2 judges or 3 judges. So it's not, the volume is enormous. So that's why there are delays. And when there are delays, a woman goes for redressal today, she'll get no relief. I had a case long back where the woman got relief, interim relief, after many months of fighting from the court. The man went to the High Court. High Court stayed the order. She didn't get any relief there. So these things also happen. So she'll immediately have to engage a lawyer in the High Court and contest that case, right? So it is, see, the law is good. I'm not saying the law is bad at all. Law is good. But implementation also, the efforts are good. But the number of spaces we should have for implementation, that is lacking.
The resources.
Number of judges we have. That you can't expect 1 judge or 2 judges per district to be able to deal with these cases. The number of cases are way too many. Right. And so there are delays.
Tell me one thing, if the husband doesn't comply with the court orders, what is the redressal?
You can file for execution.
That's it.
Yeah, you can file execution. And in fact, there is if at all you were to visit the court, you will see a significant amount of cases are actually for execution because he has not complied with it. And then on execution, because it's a court order, then he can be sent to civil prison, and all the imprisonment, all that is there. But I don't think women are interested in sending the husband to jail as much as the fact that they want the money to feed themselves, feed their child, go pay rent, pay school fees. These are real things that they need.
So is there some measure which you suggest can be brought in to kind of make sure that the orders are complied and that women do not have to really waste their time in execution proceedings?
See, if it's a salaried person, it's important. They have to find a way to actually, the salary amount be directly paid to her instead of dependent on it.
Yeah.
Otherwise, now if he doesn't pay, she'll have to make an application to get the salary attached. It's a long process. Right. So it should just be automatic that this is the amount of salaried people that has to be there. And any source of income, if somebody has, with the orders, I think if the order can actually specify the way in which the implementation also happens. Suppose the court orders today that you pay 5,000 rupees per month. If the order, because you already heard evidence, you already heard, if not evidence, at least you heard arguments on this amount. And after hearing both sides, you're satisfied that this is the amount this man can pay. Right? That is when, because you also take into account what is his capacity to pay. You don't order a daily wage worker to pay 1 lakh to his wife. That kind of rationale is not there. Right. So you have some kind of a understanding. So at that time, depending on the way the income is coming, if you bind the process also, then perhaps women can get better, because people do hide, people do run away from implementation also, and that's another long process. And many times at execution stage, they negotiate. So there are times when I've had cases where a woman is saying for 2 years he has not paid her anything. 2 years, mind you.
Yeah,
it's a court order. There's an order in her favor. And sometimes, in many cases, there's a new thing which has also happened is that matrimonial cases, they refer it to mediation. Say, settle the case. The matter is pending in mediation, the man stops paying. Just because it's pending in mediation. She's out of money. And I've seen this whole emotional manipulation which takes place with women, because many of them are very attached to their children. Many women are not willing to give their children away. And there are cases where the husband is involved with another woman, or sometimes he may even have children from the other woman. Then what happens is, so he has really no interest in looking after this child. But he knows how attached the woman is to this child. So he will negotiate in such a way that she lets go of the money so she can keep the child. So these are all manipulation which happens. And I'm not blaming the lawyers for this. Lawyers are only facilitating that whole process, and they're paid. But the people do manipulate. I've seen so many cases where they compel the woman to give up her money so that she can keep the child. And many times women, it's not about attachment. They also feel that if this child is given to this man, this child he will not be looked after. He or she won't be looked after. So they prefer that, you see, as parents, when a child is born, both sides, father and mother, we want to make sure that we want the best for the child, right? Or a period of time, if the relationship has soured and if the husband has moved on somewhere and he's met somebody else and there are other children that he's interested in, so his interest in looking after this child does get way reduced. Right. So at that time, the woman knows that, if I let go of this child and let this child be with this man, the child will suffer. I'm suffering, the child will also suffer. Right? So they let go. So these are some things which happen, and the law, I don't think, can address that in this way.
Right. With this, we've reached the end of this episode. Thank you so much for joining us, Aparna. We spoke about how the law is good in itself, the implementation efforts on the ground are good, but there are some things that the law cannot address unless there's willingness from the parties involved in these cases. However, the women are still fighting, they're still going to courts and trying their best to get the sort of assistance that they need by using this law. Thank you so much for watching. I hope you enjoyed the show. Do let us know in the comment section, and do follow us on social media and on YouTube to watch more such videos. Thank you.